अधीनस्थ न्यायालय द्वारा नियम 18 के तहत इस आधार पर कार्यवाही की गई कि निरीक्षण दिनांक को नायब तहसीलदार ने प्रश्नाधीन वाहन को निर्माणाधीन शासकीय शाला भवन के निकट खड़ा पाया था। प्रश्नाधीन वाहन को गौण खनिज के अवैध खनन में संलिप्त पाए जाने का कोई साक्ष्य प्रकरण में प्रस्तुत नहीं किए गए हैं।
खनिज निरीक्षक, where is that?
Para 3 only. Para 3. I'm just...
Para 3, yes. खड़ा पाया गया था प्रश्नाधीन वाहन को गौण खनिज के अवैध खनन में संलिप्त पाए जाने की कोई
साक्ष्य प्रकरण में
प्रस्तुत नहीं किए गए।
Correct.
So that is the submission. Part of the submission.
No, Milord. I am saying on the basis of
this finding. Okay, you've gone through the process of statutory appeal, everything.
There is a preliminary objection in respect of a revision before the Board of Revenue.
Before
the Board of Revenue. We've taken that objection in our return.
Oh, there's a revision, is it?
There is a revision provided under Rule 28 of the
Mines and Minerals.
Of the Prevention of Illegal Mining, Transportation and Storage Rules.
Yes, why not go before the revisional authority? Before?
The revision has been raised at what time? The petition is all.
Will you be kind enough to speak into the microphone, please? Yes.
See at what stage they are raising this alternative remedy objection. The petition has already been pending for pretty long time, and
just 3 hearings.
No, they have already.
1-3 was the.
The initial orders were already passed, my lord.
This is the 4th hearing. Can't say it's been pending for a long time.
No, interim orders have been passed by this honorable court, and they have never objected to that. And very well, if that is the only ground they are trying to hide upon.
It's a preliminary objection.
That's what I'm saying. That to take the preliminary objection first, your lordship is aware that there are multiple judgments and kettle of judgments of the honorable Supreme Court, right from Whirlpool's judgment.
Yeah, answer. Whirlpool, it's a bit. You see, where there is an alternate remedy, we can still excise jurisdiction. That has never been the problem. The problem is before you make us excise that jurisdiction, you have to show what are those extraordinary causes that was preventing you from going for the alternate remedy.
Very well. Allow me, I'll demonstrate that. Your lordship, I invite your lordship.
Without referring to the merits.
The alarming situations. What is required by the Whirlpool's judgment that there should be so much alarming that you have to go to Article 226 instead.
But if you don't go for Article 226, the damage or the setback you suffer is irreversible.
That's precisely what I'm trying to demonstrate. Now, my lord, the entire allegation against the whole thing is that of two aspects. Illegal excavation of minerals called murum and storage of murum. Your lordships, I'll invite your lordship's attention.
You're going into the, pardon me for saying this, but you're going into the merits of the case.
No. That's why I'm saying that is their allegation.
Or extraordinary circumstance.
Because
okay, come straight. What is the loss?
The loss is, my lord, my JCB has been confiscated.
When was it confiscated?
In 2023.
When was the impugned order passed by the appellate authority? Last order passed by the appellate authority.
The appellate authority, the impugned order is 20th November 2024.
2024.
That's
and
right.
You filed your petition in 2024.
Immediately.
We would have said that decide the revision within 60 days. You could have passed that order.
My lord, my vehicle is really in decayance and which has no role in the entire allegation.
Tell me about this. You filed this petition in 2024. Even when did you file it in 2024? Let's look at the date of filing.
Yes.
All right.
Yes.
You have filed this. This is
that is on 6th of December. 6th of December.
That's okay,
6th of December.
6th of December.
That's immediately.
We are the 9th month now. 9th month. 9 months. Your JCB has been in a state of decay in the hands of the state. Had you taken the option of the alternate remedy within 60 days, we could have got it expedited.
Look, as far as your lordships are concerned, without debating on that point, the experience is that these revenue authorities have no compassion to understand these. Ultimately, I would have to come before this honorable court and to get the justice.
You see the thing
that is the truth, my lord, which is well known. So it's
no. It's not.
That may not be the reason for bypassing the alternative remedy.
My contention. No. What my friend is saying, this is not the reason. I'm saying that is the reason.
Here we are.
Yeah.
You see, when an alternate remedy is there in the statute, it is actually a legislative intent that's option must be exercised. That's precisely why it's
true. That's not a debate.
Those whom we elect and send, they are the ones who are making the laws for us. They say that you have to do this. All right. Yours is a presumption that it would be negative, that they are this, which may be true, which may be. But there is a necessity for going through that. For example, you can say that I prefer the writ because going up in second appeal, the avenues are as it is less. The appellate second appeal court will only simply translate the order of the trial court from Hindi to English and give it the seal of approval. It does happen. But can we, on that presumption itself, say that no, we will not go for the statutory remedy. We will only go for this. Has never been a case where the Supreme Court has at least said that 226 can be resorted to because the appellate authority under the statute is merciless. You will never find a judgment to that.
No, I'm not even for a
Never
moment
be.
suggesting that.
That's why I said maybe what you say is correct. Maybe what you say is correct.
My,
Well, otherwise, what happens is everything will be brought up on drip. We even had a case just today itself, where after a regular civil appeal, first appeal is finished, he's come upon writ petition. Why are writs filed? Because they can be like any other, but not because it is an extraordinary situation, a man losing his life, a house being broken down, or patent civil liberties violations. These are things that for which these prerogative writs exist, not for something to be excised in run-of-the-mill cases. Run-of-the-mill cases, the alternate.
Look, if I fail to convince this bench that this is not this or run out of the mill case, then I hope that I could convince it because it's my livelihood which is at stake.
We will ensure that they decide it within 60 days if you find such a revision.
Milord,
Because-
allow me to at least demonstrate that
Okay.
this is one of those cases where Whirlpool had, and thereafter Whirlpool 1998 onwards.
So stick only to alternate remedy being available, yet 226 maintainable. Stick
That's
only to
precisely
that.
my effort. That's right.
Without going to the merits of the case. Leave the merits of the case. Don't
No, the
question-
very merit of the case is so alarming that my lord would be convinced.
You tell me what is the loss. Your loss should be alarming, not the merits of
The loss is my livelihood is at stake,
Right,
whereas,
but that's what-
whereas as per their own allegation, my role is zero. I'm not even on the spot. My vehicle has no role into it. And still my livelihood is at stake. That's my whole thing, that it's so alarming. Let me just allow me a few minutes.
That's another conversation.
I'll demonstrate.
All right. All right, but we won't let you withdraw after that. We pass on merits then. If
Very
we are
good.
able to, otherwise we.
Milord, I'm pretty confident that this court would definitely be alarmed by the facts.
Let us- okay.
Very well. Milord, I invite your lordship's attention to the impugned order,
Yes,
20th, that is at Annexure P5.
yes.
Now, the impugned order says that this has all been demonstrated, para 3 onwards. Married,
Yes,
अपीलार्थी की ओर से अधिवक्ता उपस्थित उनके तर्क सुने गए। अपीलार्थी के द्वारा मुख्य रूप से तर्क प्रस्तुत किया गया कि अधीनस्थ न्यायालय द्वारा नियम 2022 के नियम 23 के तहत निर्धारित प्रक्रिया का पालन नहीं किया गया और प्रश्नाधीन वाहन द्वारा गौण खनिज के अवैध खनन या परिवहन को स्थापित करने की किसी निर्णायक साक्ष्य को प्रकरण में न लाते हुए विधिक त्रुटि की गई। अधीनस्थ न्यायालय द्वारा नियम 18 के तहत इस आधार पर कार्यवाही की गई कि निरीक्षण दिनांक को नायब तहसीलदार ने प्रश्नाधीन वाहन को निर्माणाधीन शासकीय शाला भवन के निकट खड़ा पाया था। प्रश्नाधीन वाहन को गौण खनिज के अवैध खनन में संलिप्त पाए जाने का कोई साक्ष्य प्रकरण में प्रस्तुत नहीं किए गए हैं।
Manish, निरीक्षक, where is that? The last-
पैरा 3 only, पैरा 3. I'm just
पारा 3, yes. खड़ा पाया गया था प्रश्नतीन वाहन को गौण खनिज के अवैध खनन में संलिप्त पाए जाने की कोई
साक्ष्य प्रकरण में प्रस्तुत
नहीं किया गया।
correct.
So that is the submission, part of the submission.
No, Milord, I am saying on the basis of
This is finding.
the statement of the IO.
No, just.
No, whatever I'm submitting in that impugned order is to be read with the statement of IO. Because I'm verbatim.
Paragraph 3, what does it start? अपीलार्थी की ओर से उनके अधिवक्ता उपस्थित
That's
उनके
true.
तर्क सुने गए, अपीलार्थी द्वारा मुख्य रूप से तर्क प्रस्तुत किए गए।
जी।
कि अधीनस्थ न्यायालय जो एंड सो, ये फाइंडिंग कहां से आ रही है? अधीनस्थ न्यायालय द्वारा सो एंड सो is all part of your submissions. These are all the submissions.
My submissions, and I'll demonstrate that these submissions are not baseless, substantiated by documents. प्रश्नाधीन वाहन की संलिप्तता की पुष्टि करने वाला कोई जब्ती पंचनामा तैयार नहीं किया गया। प्रश्नाधीन वाहन के चालक ठेकेदार के बयान दर्ज नहीं कराए गए तथा उत्खनित या भंडारित गौण खनिज की मात्रा को निर्णायक रूप से सत्यापित नहीं किया गया। All this, now para 4 he is giving the finding. Para 3 can be my statements.
अधीनस्थ न्यायालय के मूल अभिलेख अधीनस्थ के प्रावधानों का अवलोकन कर अपीलार्थी की ओर से प्रस्तुत तर्कों एवं तथ्यों और दस्तावेजों के अवलोकन का प्रकरण का समग्र परीक्षण किया गया। अधीनस्थ न्यायालय के प्रकरण के अवलोकन से स्पष्ट है कि प्रकरण में
अब स्पष्ट है कि प्रकरण में, मतलब प्लीज रीड, इस प्रकरण में खनिज निरीक्षण छिंदवाड़ा के कथन अंकित कराए गए। खनिज निरीक्षण मींस द इंस्पेक्टर,
यस,
right? So, my lord, I'm pausing for a moment. This itself is a factually erroneous statement that पाए गए खनिज निरीक्षण छिंदवाड़ा नायब तहसील द्वारा प्रस्तुत प्रतिवेदन के आधार पर अवैध गौण खनिज की मात्रा का आकलन किया गया है। शासकीय उच्चतर माध्यमिक विद्यालय कुर्सीढाना का निर्माण ठेकेदार राममोहन वर्मा द्वारा कराया जा रहा था और अपीलार्थी ठेकेदार को प्रश्नाधीन वाहन किराए पर दिए जाने का लेख किया गया है। प्रश्नाधीन वाहन के चालक द्वारा अपने कथन में बताया गया कि ठेकेदार के कहने पर उसके द्वारा खनिज का अवैध उत्खनन किया गया है। उस उपरोक्त से स्पष्ट होता है कि प्रश्नाधीन वाहन खनिज के अवैध उत्खनन में संलिप्त था और ठेकेदार के कहने पर अथवा न कहने का कोई महत्व नहीं है। So my lord, I am stopping here, and my lord, I am taking my lords to the inspector's statement, which is at P2, annexure P2, the IO's statement. That is at annexure P2, page 14. Lords got that?
Yes.
Married?
Yes.
मैं स्वाति ठाकुर खनिज निरीक्षक सच एंड सच शपथ पूर्वक कहती हूँ सच एंड सच कि दिनांक मेरे द्वारा दिनांक 2/9/22 को उत्खनन कर्ता राम मोहन वर्मा ठेकेदार अकलसी ध्रुवे सच एंड सच ड्राइवर के द्वारा किए गए खनिज मुरुम उत्खनन के संबंध में आकलन प्रतिवेदन पेश किया गया था। सच एंड सच अमाउंट एटसेट्रा बिलो, दैट इज नॉट इंपॉर्टेंट। द आफ्टर दैट द सेकंड पैरा, प्रति परीक्षण में अनावेदक सतीश मिश्रा के द्वारा अधिवक्ता सच, यह कहना सही है कि मैंने जेसीबी मशीन को खुदाई करते हुए नहीं पकड़ा। स्वतः कहा कि पूरा प्रकरण राजस्व विभाग द्वारा बनाया गया है। यह कहना सही है कि हमने कोई जब्ती पंचनामा आदि तैयार नहीं किया है। जो भी प्रकरण में मिला राजस्व विभाग द्वारा दिया गया है। यह कहना सही है कि मेरे द्वारा न तो ड्राइवर का बयान लिया गया न ही ठेकेदार का बयान लिया गया। यह कहना सही है कि मेरे द्वारा मूल्यांकन करते वक्त कोई स्वतंत्र गवाह नहीं लिया गया। यह कहना सही है कि तहसीलदार तमिया द्वारा 8-10 मुरुम उत्खनन का निर्माणाधीन भवन के निर्माण हेतु भंडारण किया गया था। स्वतः कहा कि रेवेन्यू ऑर्डर शीट में लिखे लंबाई चौड़ाई ऊंचाई मूल मात्रा 150 घन मीटर का है, जो मेरे द्वारा मूल्यांकन किया गया। मेरे द्वारा किसी भी के कोई कथन की जांच नहीं की गई। यह कि मेरे द्वारा केवल आकलन का प्रतिवेदन किया है। स्वतः कहा कि मेरे द्वारा बाकी कुछ नहीं किया गया है। Now, my lord, this is the IO.
That's the
Who's
mines inspector.
who's admitting that she did nothing.
Doesn't mean someone else did.
No, I'm coming to that also, my lord. I'll demonstrate it to the hilt. I'm not leaving it over here only. I'm simply saying, as per the rules,
You're going to the evidence, you're not telling how this is, anyway.
my lord, Ravi, as per the rules, the one officer who's responsible to undertake all these jobs is simply saying, I never did that.
All right, then.
And, my lord, if I invite your lordship's attention to the rules framed by the government.
Just a moment, there's some machine
Yes, ma'am.
also, it's a driver. पहली गाड़ी मालिक के कहने पर ये दूसरा वाला देख लो ना, पेज नंबर 15 पे वो लिख रहा है कि मैं आया तो अंसो और मैं सीधे से ड्राइवर है ना,
गाड़ी मालिक के कहने पर गोष्ठी नगर रोड पर बिल्डिंग बनाई जा रही है। ठेकेदार का थोड़ा
मुरम खुदाई चल रही है। तो मुरम खुदाई चल रहा था। ये क्या मुरम ट्रैक्टर जो शासकीय भूमि से में कर रखा था। The driver is stating so.
I'm sorry, sir.
The driver said, come to page number 15.
No, that I have. See, with the return, they have annexed the driver's panchanama, everything. It is so clear that all this is being made up.
How can we?
I'll demonstrate from the document.
Counsel, just a moment.
Yes, ma'am.
You're not going to convert this court into a trial court.
No, not sure.
If this is evidence for us. Don't say that it is in conflict with some other evidence. And this person is telling lies, that is telling truth. Because there are two lies together, none of them can be believed. Don't go into all that. If you're going to all that,
I'm not going to the merit of the case.
You
or
are going to the merit.
No. I'm not saying that this court is a trial court. I'm simply saying that what they have submitted, the document speaks of itself.
No, what is wrong with the Shapat Purvak Kathan of this man? Who is the driver of the vehicle? He says that he is the one who has been doing the excavation of the behest of the owner.
Look, they have annexed that. Is this some shapat? That's what I'm saying.
I'm not concerned. This is what this is for the department to first of all consider. That's what I'm saying. Am I going to consider this? Whether it is on oath or not, we are going to look into that.
My lord, if there is anything on shapat, it
He
has
may have been administrative overload there.
No, but then there should be somebody.
Forget it. That's what I said. Don't reduce this to other things. Sorry, we will not let you argue into that lines. Now come back. How is it, deleterious to you? I'm sorry. Till now, we are not able to agree with you. There is nothing that this court needs to do under Article 226.
My lord, neither the spot panchanama.
There's an abuse of process. You're bringing it to us that it should never have been. This should not have been brought.
My lord, the procedure prescribed by the statute.
Say that before the revisional authority. They can look into it. Do you want to withdraw with liberty? We can give it to you right now also.
No, no,
Are
in
you
case if
arguing
I'm,
it will not?
no, no, in case I'm failing to convince my lords,
No,
I have,
I'm sorry, but absolutely. Sometimes it becomes very clear from the word go that there is actually nothing in it.
my vehicle is being in decadence for 2.5 years.
You are the one who was wasted 9 months. Had you
No,
gone to
I
the
have
board
been
of
pursuing,
Revenue,
I've been
had
pursuing
stopped
these, even the collector has admitted that the vehicle has no role.
You see, that is your submission that has been recorded. It is not his finding.
No,
It's
because
not.
that has not, JCB Milord is not a storage vehicle.
So,
And there is nothing been kind of
no. If you
excavation.
want to withdraw now. Otherwise, if there's an order on merits.
Very well, Milord,
counsel for the-
very well. I'll withdraw with liberty to file.
File the district, learn counsel for the petition.
Milord may
Arguing for
expedite
short
that
while.
revenue.
After arguing for a short while, comma, wants to withdraw this petition with liberty to pursue the alternate remedy before the Board of Revenue. Full stop. If full stop, the petition is dismissed with liberty as aforementioned. Full stop. If such a revision is filed before the Board of Revenue within 15 days from the day, or do you want more time?
No,
15 days, 15 days from the, within 15 days from the date of this order, comma, as accompanied by application for condonation of delay, comma, the Board of Revenue is requested not to reject the revision merely on the grounds of limitation, as the petitioner was bona fidely pursuing the remedy under the writ jurisdiction for a little over 9 months after the impugned order was passed. Full stop. Under the circumstances, comma, this petition is dismissed, is withdrawn with liberty as aforementioned.
Milord, one more thing, that the revenue authority should decide it within 60 days.
Yes. Full stop. If such a revision is filed within the above stipulated time, comma, the Board of Revenue is requested to decide the same expeditiously and if possible within a period of 60 days from the date of the with the above petition stands dated.
Thank you.